So everybody's here. Okay.
Thank you.
Oh,
At this time, I would like to remind council and municipal staff that this meeting is being live streamed to the public. All council meetings are also recorded. Recordings will be available to the public on the township's YouTube account. This meeting is held electronically under bylaw 2020-70 to amend procedural bylaw 2018-117 pursuant to section 238 of the Municipal Act 2001 as amended. I will call the meeting to order at 9:34 in absence of the mayor. As per bylaw 2018-119, Councillor Carl Bromwich is the appointed member of council authorized to act in the place of the head of council in the absence of the mayor, with authority under section 18.3.2 of the procedural bylaw to chair this regular council meeting.
and I'll request the CAO read the notification, please.
One of the purposes of the Planning Act is to provide for planning processes that are open, accessible, timely, and efficient. Accordingly, all written submissions, documents, correspondence, emails, or other communication, including your name and address, form part of the public record and will be disclosed, made available by the municipality to such persons as the municipality sees fit, including anyone requesting such information. Accordingly, in providing such information, you shall be deemed to have consented to its use and disclosure as part of the planning process.
I'll now request the CAO to read the First Nations land acknowledgement, please.
As we gather today, I would like to acknowledge on behalf of council and our community that we are meeting on the traditional territory of the Algonquin people. We would like to thank the Algonquin people and express our respect and support for their rich history, and we are extremely grateful for their many and continued displays of friendship. We also thank all the generations of people who have taken care of this land for thousands of years.
Is there any declaration of pecuniary interest?
None.
And I see none.
None here.
I see none. I would ask Silas to proceed with the purpose of the meeting, if you wouldn't mind. Silas, thank you.
Thank you, Mr. Chair. Before we proceed, I would like to amend the agenda by adding item 8.2. And that item is the email exchange between Robert Howe starting on March the 11th to March the 14th between myself, including Lindsay Bennett from the County of Renfrew. I did forward a copy of that email exchange to all of council and parties involved. So I just wanted to add that. So having said that, we will then proceed with item number 4. The purpose is to hear a person's comments in regards to zoning bylaw amendment application made by the applicant. And the application was made by Robert Howe from the firm of Bradley Law Professional Corporation on behalf of the owners, Christopher, Dorothy, Richard, and Thomas Poweska, file number POW-2020-01. Attached is the application, which forms pages 5 to 22. Are there any concerns, comments with respect to the application from council?
I see none.
None here.
None.
Okay.
Silas,
Very
can I
good.
just get clarification, please?
Yes.
I wasn't sure if it was a typo. Is it file 01 or 02? I had 02 on.
It is 02.
Okay, thank you.
Okay, proceeding to item number 4.2 is page 1, the cover letter from the County of Renfrew, dated February the 4th, 2022. Item 4.3 is the County of Renfrew Planning Division Zoning Bylaw Amendment Report to Council, dated February the 4th, 2022. And that may be found starting on page 25, going to page 28. I don't know if there are any concerns at this point of the meeting from council or the applicant, but I think we will be addressing that with the new added item 8.2 that I just added. So I think we can move forward to the next item, which is item number 5. The purpose of 5.1, the purpose and effect of the amendment is to rezone a waterfront property that is 1.56 hectares converting to 3.85 acres in area to reduce the minimum water setback from Trout Lake from 30 meters to 24 meters in order to permit a dwelling. The effect of the amendment is to rezone the subject lands from limited service residential LSR to limited service residential exception 56 LSR-E56. Moving on to item number 6, the report on the application and notice. 6.1, notice of complete application is attached and was mailed out on February the 4th, 2022. Item 6.2, the notice of application and public meeting were sent out to all affected property owners within 120 meters, which is 400 feet of the subject application, and to all public bodies as required on February the 10th, 2022. Item 6.3, notice was posted on the subject property on February the 10th, 2022. Item number 7, notice to public bodies, written responses and/or telephone messages. 7.1, Ontario Power Generation Inc., email dated February the 10th, 2022. There were no comments or concerns. Item number 8, written comments. 8.1, email from Ryan Gibson and Amy Volume, and response dated February the 14th, 2022. They are property owners within the vicinity of the subject application, and they just needed some clarifications. They're new owners and weren't sure if it affected their property. And I had a telephone conversation with them. They have no issues or concerns and know the Poweska family very well. So that would cover item 9.1, the telephone conversation on February the 14th, 2022 with Ryan Gibson and Amy Volume. So going back to items number 8.2 is the email exchange between Mr. Howe, myself, and Lindsay Bennett. And the point raised by Mr. Howe was the requirement for the EIS study, which was the recommendation in the County of Brantford planning response. And as Mr. Howe pointed out, it does state that the EIS may be required. And if council did see the response from Lindsay Bennett, who was the author of the report, said that there is the recommendation that an EIS study be done. So I'll just leave that to the applicant and council to discuss, and I'll turn it back over to you, Chair Bromwich.
Thank you.
Thank you.
Is there any oral or written presentations by those in attendance? And do I see anybody? There's Mr. Howe. You have anything to offer us, Mr. Howe?
Well, thank you, Councillor Bromwich, and thank you for the opportunity to speak to this matter. I think the only, this is a fairly straightforward amendment to reduce by only 6 meters approximately the specified water setback of 30 meters. As the sketch attached to the application shows, this property is a very steep property, although extensive at over 3 acres, but it's very steep, as Mr. Simpson's plan shows, and as noted thereon, really right from the back right down to the front. This matter started 4 years ago, believe it or not, when your chief building official identified a small building perched on this cliffside, if I can call it that, for which no permit had been granted. And it proceeded from there to the point where I received on the 6th of January of this year from Mr. Dombrowski this email: the township will issue a permit for the greywater composting system leaching bed as requested by Sunmar composting toilet system. Once the zoning amendment is completed, we will be able to issue a permit for the addition to bring the present structure to the minimum required size of 55 square meters to meet our zoning bylaw and meet the Ontario Building Code requirements. So the point here is that I think from the terrain, it's clear that there's probably no place other than where it has been put for any structure to be placed sensibly on this property. And secondly, that there has been extensive investigation by Mr. Dombrowski, the chief building official. There won't be any human sewage discharge because they've installed this Sunmar, as he refers to, a composting system that is self-contained. His other concern, of course, was about gray water. And at this point, this leaching bed that he refers to has been installed, and apparently to his satisfaction, if he's prepared to issue a permit for it. So that I think, although in many cases it's necessary, and of course the other thing that the council probably is aware of is there are plenty of long existing cottages on Trout Lake that are located as close or even closer to the water's edge, and may have conventional septic systems. But that aside, I would submit that this, because of the special circumstances, is one in which the council should exercise its discretion not to require an EIS report, which, for the reasons I've mentioned, would almost certainly suggest that there weren't any issues. The other thing too, if you read the section in the official plan that's being referred to here, it talks about possibly putting in a requirement for a vegetative buffer or something like that, which conceivably could come out of an EIS report. But again, in this case, we're dealing with a very steep downgrade from the buildings to the water, and it's it's because it's rocky as well that one can't install a conventional septic system despite the size of the lot, that there's probably not very much that could be done in terms of shoreline alteration on this property, although that's a bit of speculation on my part, and I guess with enough heavy equipment you can do almost anything anywhere. But anyway, I'll leave it at that and suggest that this amendment should be approved, and that it needn't be otherwise supported than it has been already, to the extent of the investigations undertaken and the position now apparently taken by your chief building official.
Thank you very much, Robert. Appreciate your input here. Do we have any questions or discussions by council members? Yes, Ernie, would you like to speak on this?
I would. Thanks, Mr. Chair. I see that there doesn't appear to be any changes to the use. And I really don't see the reason why we would want to be doing an EIS, the study is scope report. I think that I know it's the responsibility of the county to, and in just about every situation, they make the same recommendation. And we as a council have the right to look at it and our duty to make a decision. And I would say that being consistent with what we've been doing in the past, and in that particular case, not to require this particular report. So that would be my position on this. Thank you.
And to you, Councillor Wilmer.
Yeah, I concur, and I agree with everything that Mr. Howe said. I think in this case, we're bringing it up to the 55 square feet, or not square feet, but the right size for a dwelling. I think they've made efforts on a very difficult piece of property to do it well with the composting toilet, and I think, as has been mentioned, there are other cottages or dwellings on this lake that are much closer to the lake. So I think they've made every effort they can on a difficult property to do this properly. So I fully support it. I don't think we need any reports.
Anybody else? That's you, Mr. Schulist.
Yes, Mr. Chair. Yes, I have to totally agree also with Councillor Poplinski and Councillor Wilmer. And Mr. Howe, I think they've done their due diligence on this, and I myself have no problem. And so I will definitely support this. Thank you.
So now, Silas, you have a draft copy of the bylaw.
Thank you, Mr. Chair. Yes, I prepared the bylaw accordingly because I didn't know what the decision was going to be of council, whether to request the EIS study. That is why the bylaw has been drafted in first and second reading, allowing opportunity for the study to be done. But just hearing what council and committee have said, it appears that council will proceed to actually enacting the bylaw. So therefore, it would receive all three readings if that is the case during the council meeting. So that is all that I have to say on the draft bylaw. Thank you.
Thank you, Silas, very much. Now I'll ask the CAO to read the notification, please.
Sue, you're muted.
Thank you. Council is also required by section 3414.5 to inform the public at the public meeting of who is entitled to appeal to the Ontario Land Tribunal under sections 3411 and 19 as follows. Section 3411, if council decides to refuse an application or refuses or neglects to make a decision on an application within 90 days of the municipal clerk receiving the application, the applicant or the Minister of Municipal Affairs may appeal to the Ontario Land Tribunal by filing an appeal with the clerk of the municipality. Section 3419, not later than 20 days after the giving of notice of the passing of the bylaw, the applicant, any person or public body who made oral submissions at the public meeting or made a written submission to council before the bylaw was passed or the Minister of Municipal Affairs may appeal to the Ontario Land Tribunal by filing an appeal with the clerk of the municipality.
I now call the meeting closed. Thank you, Robert.
Thank you.
Councillor Bromwich, could I have 30 seconds?
You may, sir.
Okay, I'd like to take them. I'm retiring. I'd like to express in this setting my appreciation for a 44-year-long working relationship with Silas Lorbetsky. About half of it as a member of the Howe Law Office, and the other half as a loyal and faithful and I'm sure much appreciated employee of the township. He's just been wonderful. He was a marvelous ambassador for my office when he was working in it, and I'm sure is as well for the township to this day.
Thank you very much, Bob.
Thank you, Robert.
Well said.
Good luck in your retirement.
Yeah.
Thank you.
You deserve it.
Oh,
Silas, to
Silas.
you.
Thank you, Mr. Howe, for that very heartfelt comment. And one comment I'm going to make, your letter of reference that you gave me the day I left your office was saying that you would hope that we could retire at the same time. Well, lo and behold, I'm retiring on April the 29th. So grab your kayak. Here we go. Thanks.
All right. Glad to hear it.
Thanks, guys. Appreciate
Thank you.
it.